SJC-12811, Commonwealth v. Reynolds J. Buono.
I'll make sure I get the right case.
Ms. Grant, good morning.
Good morning, Your Honors. Marguerite Grant, Assistant District Attorney from Norfolk County on behalf of the Commonwealth. And with me this morning is Lisa Beatty, who is the prosecutor in Superior Court. The defendant's absenting himself from the Commonwealth of Massachusetts for 3 decades told the statute of limitations, the requirement added to the statute of limitations in 2006, that a child sexual abuse case be corroborated by extraneous evidence. That, in this case, there are very few cases construing the 2006 amendment to the statute of limitations. The main one that was discussed in the court below is Commonwealth v. White. My concern with Commonwealth v. White is that in that case, it was undisputed that the mere passage of 27 years since the crime meant that this corroboration requirement kicked in. As I read the statute, that's actually not the case. The tolling requirement, the tolling provision should apply in a situation like this where the defendant has absented himself from the Commonwealth. The legislative history of the 2006 amendment that was discussed in Commonwealth v. White, and I've included it in the appendix to my brief, that legislative history did not discuss the tolling provision. And so the words of the statute, the plain meaning of them is that any period when the defendant is not usually and publicly a resident of the Commonwealth is excluded in determining the time limited. The words "the time limited" should apply to those 27 years.
Well, that is another meaning, doesn't it? The time limit, doesn't it usually refer to something specific?
Well, the time limited, the prosecution of a child sexual assault is limited after 27 years in that it can now only be prosecuted if this corroboration. It would make no sense to not construe the statute the way I'm asking the court to, because it would mean that if this defendant had raped a 16-year-old back in 1981 or 82, he could still be prosecuted without any corroboration requirement. But because he raped a 15-year-old, that 27-year corroboration requirement would kick in, and that would be an absurd result.
Why?
Well, it's for exactly all the reasons that the legislators talked about in making this amendment. They sought to expand the ability of child sexual assault victims.
Basically, to do away with the statute of limitations and say you can do this forever. You can do it any time during, it can be 35 years so long as you, it's just that after 27 years you have to have this corroboration. It's not that there's no statute of limitations. It's like murder, there's no statute of limitations anymore.
Well, there were some legislators who talked about wanting to do away with the statute of
But if
limitations.
you read the statute, it's what it says. It's what it says,
Well,
right? I mean, that's what it says. It
the
says,
the caption says an act increasing the statute of limitations, the title of the statute. And then it says,
may be found and filed at any time after the date of the commission of such offense, at any time.
correct.
But at any time, that means that there's no statute of limitations. But any indictment or complaint found and filed more than 27 years after the date of commission of such offense shall be supported by independent evidence that corroborates the victim's allegation, right?
Correct.
It's not that there is no, it's not that there's no limitation here. It's not a statute of limitations. It's just a condition. If you're doing it after 27 years, you have to have independent corroborative evidence, right? You can do it so long as you've got independent corroboration.
Correct, except that if the defendant has voluntarily left the jurisdiction for 30 years, that is part of the reason why victims might not come forward. Once the defendant is gone, he's literally on the other side of the world.
The concern with the independent corroborative evidence wasn't anything to do with that. It was to do with the fact that they were fearful of false memories.
There were some legislators who
It's a compromise. This is clearly a compromise statute.
Well, there was discussion in the July legislative history that's included here. There was more discussion over that summer of 2006. It was finally adopted in September. There were various statements that were made. One of the things that was proposed by, I believe it was Representative Baddour from Methuen, was, well, we could have a statute of limitations longer if there's a scenario where the defendant has, the victim's delay is as a result of some sort of threats or psychological coercion by the defendant. There's absolutely no discussion of tolling anywhere in that legislative history, and I think that the court, in construing the statute, has to assume that the legislators knew of the tolling provision. That's a basic canon of statutory construction. They have to have, the court has to assume that they knew about the tolling provision. They weren't discussing tolling situations. The closest they get to it is a scenario, as I said, where there might be a fact scenario where a defendant has threatened a defendant, and that's why they haven't come forward. With due respect to the appellate prosecutor in Commonwealth v. White, this issue wasn't reached because, and White says the issue was undisputed that the tolling provision, well, it was undisputed that the 27 years applied 27 years after the crime. I am disputing it here, and Judge Connors reported the question because it's an important question, and his discussion with me at the motion to reconsider hearing shows the confusion that trial judges and motion judges face in dealing with this. If one looks at the statute of limitations, as I said to Judge Connors, it almost looks like alphabet soup. It's a list of statutes and with different limitations that apply to different statutes. It's not until someone plugs in the different statutes, child rape or rape of an adult, that this anomaly becomes clear that the statute of limitations wouldn't, or the corroboration requirement wouldn't apply at all if the defendant had raped a 16-year-old.
But is that because with adults we're less concerned about memory disappearing than we are with children?
I don't think that, given the legislative history and the case law, I don't think that you can say that there's any kind of a basis to say that the legislature finds that children are less credible.
Can I ask, are you also asking us to revisit, and one question I have is, on the corroboration requirement that it be specific to the actual crime charged, that part, are you also asking us to revisit that? And was that dicta in White, or was that part of the holding in White?
Well, the corroboration.
I'm bothered by the fact that we have corroboration in August here, confessions, corroboration, everything, but that's in September. We may not have corroboration, and that to me seems like not what the legislature had in mind on corroboration, but go ahead.
Well, I think the difference between the corroboration here and the corroboration in White is in White, it was a subsequent bad act that the victim's brother had observed in, I think, onset, when the crimes charged happened in Wareham. In the SJC, the court said that it needs to refer to the specific crime at issue. Here, the corroboration is the defendant's own statements.
Right, but I understand you have an argument there's corroboration for September, but I am bothered by the fact that when we're dealing with 27-year, the lack of specific corroboration seems unrealistic. And I'm trying to understand, was that a part of the holding in White, or was that just sort of our, further analysis that wasn't necessary there?
I'm confused when you say August and September. You're talking about in Italy and in Milton?
In our case, we have corroboration of a rape in Italy, or a sexual assault in Italy. And then we may not have corroboration for the September incident. But that just, to me, the purpose of the corroboration rule was to make sure we're not dealing with made-up events. But and I'm worried that we may have painted ourselves into a corner in White unnecessarily. So, and I was wondering whether you were asking us to revisit that.
I am. The way that I'm looking at it is it's a distinction between corroboration by a defendant's statements versus corroboration by a prior or subsequent bad act.
So you don't really think White says that the corroboration has to go right to an element of the offense. You don't take White to hold that.
No.
Okay, so
the
because
way
you take White to be, well, it's a prior bad act that would be otherwise inadmissible, or even if it is admissible, that can't corroborate. But why can't what the defendant said in Italy shortly before the incident being prosecuted constitute corroboration? It's sort of common sense that it does.
the words White uses is a material particular. It has to corroborate. And that's why I'm trying to distinguish between his statements about the event versus a prior bad act. Statements are a much stronger form of corroboration. So if the White defendant had said, well, I didn't rape the victim in Wareham, but I did rape her in Onset, that would be sufficient.
And there's nothing in White that says it isn't.
Correct. And one of the strongest cases on this for me is Commonwealth v. Odell, an appeals court case written by Judge Cass. I'd say at one point it was written by Judge Smith, but I made a mistake, where the defendant was being prosecuted for sexually assaulting teenage girls, a girl, and giving her drugs. While he was out on bail, he said to his nephew, why don't you call up a bunch of your teenage girlfriends, find out what drugs and alcohol they like, and we can have sex with them. The nephew never did so. That came in as a subsequent bad act. The defendant argued, well, it wasn't an act, it never happened. The nephew never called them. And the appeals court said, well, it's better than an act, is what Judge Cass said, because it's pure intent. So his statement, even though the subsequent rape never happened, it went directly to the event. And there was also this funny corroboration statute, 27211, that came up in White as well. By analogy, it also came up in Helfand. So there, the defendant, it was charged with drugging for sex. And that had to be corroborated under 27211. And the appeals court held that the corroboration requirement was satisfied by evidence that the defendant had given drugs to a different girl victim, and that was sufficient corroboration. So here...
That case is way before we issued White, isn't it? I mean, just...
Oh, yeah.
Justice Cass has been gone for a long time.
But it goes to my point that defendants' admissions are a much stronger form and much different...
Because, is it your position that if there was an eyewitness to the sexual assault in Venice, that would not come in under White, because that's a prior bad act?
Well, I would probably be arguing that if that is what White holds, that White should be reversed.
Okay, I know that, but I mean, under White, isn't it? I mean, White was prior or subsequent bad acts, and it said, and I quote from White, "We conclude that the corroboration must relate to the specific criminal act or acts of which a defendant is accused, and that evidence of uncharged misconduct does not suffice." That's a quote from White. That's
Correct.
pretty clear. Correct?
Correct.
So assuming White is still good law, you can argue that we should undo it, but if there was evidence that somebody observed the sexual assault in Venice, it would not be viewed as corroboration under White, correct?
Correct.
So, but you're saying that if he said, I did a sexual assault in Venice, that it then comes in?
Against this victim, absolutely, because...
Even though he's referring only to the prior bad act?
Well, if you have a scenario where, as I said, if the defendant said, well, I raped her in Onset, but I didn't rape her in Wareham, that goes absolutely to corroborate the victim's statement. But here, the strongest evidence of corroboration is that comment in the spring of 1982 to the victim's friend in the basement of the Milton Academy classroom building. It's not going to happen again. He's saying that in the spring of 1982. It's echoing a conversation he had with the same person a year before in Italy. He calls the person aside. From that, the grand jurors could infer that it had happened again since Italy, i.e. in Milton, with the same victim, and that's a question for the jury to decide, and not at the grand jury stage. That's why
I'll stop you there, too. So you're saying basically that you could present evidence to a grand jury that's put aside the statute of limitations, put aside the tolling issue, that you present you charge a defendant with a 30-year-old rape before a grand jury of a child. You have no corroboration of it, apart from the accusation of the child, who's now an adult. You can get an indictment from that and go to trial with that? Is that your position?
well, that's a tautology. If the question
No,
says
you're saying that you don't need to present any evidence of corroboration before the grand jury, that it's purely an issue whether the evidence is sufficient at trial.
I'm not saying you don't need to present evidence before the grand jury. I'm saying the evidence we did present of corroboration before the grand jury is sufficient here. By the standard.
I could have sworn you argued that you don't need to present it before the
Well,
grand jury, that the issue is at trial.
under Roman numeral 1, under the statutory construction issue, that the tolling provision applies. If the court rules in the Commonwealth's favor, that's true. But the Commonwealth did present corroborating evidence here.
Okay, so, and that goes to the meaning of what it is,
Well,
of what the reference is to
in
it, which
the
must be.
context of the defendant's prior statements in Italy and his subsequent statements in 1987, and reminding the court of Commonwealth v. Carrillo, which is cited in my 16L letter, that the standard of proof at the grand jury is a very low bar. And here, the Commonwealth more than met that bar on the evidence of corroboration. Unless the court has any other questions, I will rest on my brief.
Okay, thank you. Ms. Bernstein.
Thank you.
May it please the court, my name is Inga Bernstein, and I represent the defendant, Reynold Buono, in this matter. The Commonwealth wants you to encroach upon the legislature's domain in crafting a statute that sets out, in eliminating the statute of limitations, a corroboration requirement. And
Counsel, I'm sorry to interrupt you, but
That's
what
okay.
about the last sentence of the statute that says any period during which the defendant is not usually and publicly a resident within the Commonwealth shall be excluded in determining the time limited? Doesn't that just take him right out of this and for purposes of proceeding?
I don't believe so, Your Honor, and I'll tell you why. First, you're going to look at the statutory language, obviously, to understand what it means. So the idea that the 7 justices of the SJC in white and the Commonwealth in white totally missed the idea that tolling, which was a live issue in that case, because that defendant had been out of the Commonwealth for some period of time, and there was a whole question about was there tolling and was it a 15-year versus this now no statute of limitations, what applied. So this court actively wrestled with tolling in white, and nobody thought of it. That suggests to me, just at first blush, that it's not, the statutory language doesn't plainly say that. But let me ask you to take a look at the statute with me. Because the statute, which is a statute related to limitation of criminal prosecutions, it says murder may be found at any time after the person is killed. This constellation of crimes may be found and filed at any time. Rape, assault with intent to rape, can be found in 15 years. Robbery crimes and incest can be found in 10 years, and everything else can be found and filed in 6 years. And then we get to the last sentence. Any period during which the defendant is not usually and publicly a resident within the Commonwealth shall be excluded in determining the time limited. The time limited means statutes of limitations. That is what this statute is about. And the language of the statute, that when you look back at the history of where this language came from, makes it even more clear that the last sentence of the first paragraph applies to statutes of limitations. That in 1836, when the this statute was first enacted, there was only murder, which had no statute of limitations, and then there was everything else, which had a 6-year statute of limitations. And the statutory language at that time said, but any period during which the party charged was not usually and publicly a resident within this state shall not be reckoned as part of the 6 years. It's saying the statute of limitations will be told if the person is outside of the Commonwealth. When in 1902, when the language of the statute is amended.
So we're in a certain, and I don't disagree that your linguistic interpretation makes some sense, but so we're kind of rewarding the fleeing felon. So if you disappear to Thailand for 27 years, you've now imposed this specific corroboration requirement that you wouldn't have to do if you hadn't fled for.
Well, I think,
is
first
there
of all,
some logic to that? I mean,
Yeah,
what's the logic to that?
Well, that's not this case, because I think although they've said he fled, there is evidence in the record presented to the grand jury that people knew where he was and that he wasn't.
But the purpose of that last sentence is to deal with the fleeing felon, right? So we're rewarding a fleeing felon with this corroboration requirement, aren't we?
What you're doing is what you're doing is honoring the legislative balancing that says, yes, we want to give victims time to come forward if there are claims, but also we've got some concerns about the reliability of evidence when it involves only the testimony of child victims. And therefore, when you've got these super old cases, that we're going to require corroboration. You have to look, and that's another reason I would say that the last sentence of the first paragraph doesn't apply to the clause of the statute that deals with corroboration, because it deals with an entirely different purpose. The time limited deals with statutes of limitations, which are told.
I can buy that. My problem is the specific corroboration. I understand you're interpreting what we've written. Was that necessary to decide in White that, because I understand the purpose of this corroboration requirement is we don't want old cases, 27-year-old cases without corroboration. But here we've got corroboration 1 month earlier. Is the logic of the rule that you should bring that case and not this other one? I have real trouble thinking that this doesn't corroborate.
Well,
I mean, it makes no sense. He's admitted to raping the kid 1 month earlier.
Well, no, he hasn't. So I'll wrestle with you on the facts of that, first of all. But I think Justice Gantz properly framed the White holding, and it's essential to the holding.
It was. Why is it? Was it essential to the holding?
It was
in that case?
absolutely essential to the holding, because the corroborative evidence that they were pointing to in White was the brother of the victim who saw behavior that looked very similar to what was being charged, but it happened in a location different than, and therefore could not have related to the specific event. Mm-hmm. And so in White, what the court said is that's not enough because it doesn't relate to the specific event alleged.
So you couldn't use pattern and practice evidence either? Modus operandi? None of that. You know, you've got a guy, and I'm not saying this is this case, but we have some person who's consistently raping kids out there. We have a pattern that he does it by giving them alcohol and gets them drunk and then abuses them each time. But we don't have corroboration on that particular day. We just have this pattern in practice. Is that also excluded by White?
It's also called propensity evidence, and I think that there's a very...
That's not modus operandi. It's not propensity.
Situation. He's outlining a grooming situation, and we have enormous amount of cases that would allow that in. So if you take Justice Caffrey's question as it would be admissible in the case, the prior bad act would be admissible for a non-propensity purpose, but are we supposed to take White to say but it wouldn't be available for corroboration because it didn't go to the element of this particular crime?
Yes, I think
Because that's crazy.
And you think that's what the legislature intended?
I think that the legislature intended, well, this court decided that that's what the legislature intended, and that's what made sense given the corroboration requirements. There was a look at how do we handle corroboration, and the looking at the case, those cases, and the concerns targeted by this corroboration, which is the reliability of evidence, makes it, yes, it's got to be about this charge. And so I'd like to touch, too, though, on the other aspect.
I can see a logic to it, meaning that you should only bring charges on the ones where there's corroboration. But I don't see any logic that it doesn't provide. I mean, because the big concern is made-up memories and kids, and, you know, we all know what these cases were that we're dealing with, but the fact that we have confirmation of something that happened 1 month earlier to treat it as irrelevant, I find bothersome.
Well, just to be clear, what was alleged to have occurred in Italy was not the same as the crime charged.
If that were the crime charged, wouldn't that be enough for corroboration? If we had the Italy incident, we were prosecuting the Italy incident, you don't think we have enough corroboration to satisfy White?
Not under White. And I'll tell you one reason why you should really worry about this. Because first of all, the Norfolk County District Attorney's Office knew about these allegations back when they first came forward in the 80s, right? They knew it, and they didn't prosecute it.
Those were the bad old days.
Well, perhaps, but at least as to what was alleged in this case, they didn't think it occurred. So there is a question as to did anything occur. The Commonwealth well knows they can't prosecute Italy. The Commonwealth knows they can't prosecute Cape Cod. The Commonwealth can only prosecute.
Why can't they prosecute Cape Cod, I'm sure?
Well, Norfolk County can't.
Right, but somebody can.
Somebody could, but that's not this case. This case is Norfolk County prosecuting acts alleged to have occurred in Norfolk County that were never brought forward. The DA back then said, well, obviously that's Italy. There was no talk at that time of Cape Cod. There is a concern that nothing happened in Norfolk County. And that's why one thing you need corroboration. There is a case that an alleged victim and a prosecutor want to prosecute, but they can't just say, yeah, it happened in Norfolk County. There's got to be corroboration. And I submit that we should all care about the reliability of evidence that this component of the law was targeted to address.
You know, but it's kind of interesting because if you think about corroboration or in this context, if we had a case where a defendant was accused of perhaps serially raping several different boys, then there's no doubt evidence of the other acts could come in as corroboration of an act charged.
Well, that's not this case.
No, but
and so the question is, in this case,
maybe it is this case, though, when you think about it.
Not as it's charged. They can't just say, we think this is a bad guy. This is kind of, I get the impulse to want to say that and to want to find that, but that's not how, our law has got to be more dispassionate than that. And what the legislature was concerned about was reliability.
Is fleeing to Thailand in particular corroboration of anything?
First of all, there's not
Not
evidence
fleeing,
of
but
fleeing,
going.
which would be
Going
a
to
question
Thailand.
of fact.
Can we draw any inferences from that?
I don't think so.
Okay.
I mean, there is in the evidence, and I think this went to the grand jury, that people knew where he was, including knew where he was before the allegation that he was abroad. So I want to go back to what we think of as the absurdity argument that the Commonwealth has made, that why would you treat a 16-year-old differently than a 15-year-old? And this is line drawing. We have to deal with some bright lines. And so that's where the legislature drew the bright line and said there is a 15-year-old victim. For that person, there is no statute of limitations. For a 16-year-old victim, there would be a 15-year statute of limitations. For a 15-year-old victim, you would need, if it's old, obviously, corroboration. For a 16-year-old victim, you wouldn't need corroboration. For a 15-year-old victim, you wouldn't have to deal with any of the tolling questions because there is no statute of limitations. That's a fundamental part of this, too. There is no statute of limitations. There's not a case where we've got 2 statutes of limitations for one crime. That just doesn't happen. We have 1 statute of limitations for the crime, and in this case, the charge can be brought at any time. But because we're concerned about reliability, because we're concerned about a fundamental due process, we need to make sure that there is corroboration for these old cases. And so there are reasons that the line drawn, and just because it's a little uncomfortable, or maybe at the...
Well, I don't know if it's a little uncomfortable. It's a lot uncomfortable if you can rape someone in Italy. Again, I'm not saying that happened. I'm just saying that if he had admitted to a rape in Italy and it's completely irrelevant, in fact, the same boy in a lot of the same circumstances, and that doesn't corroborate something that happened a month later in the United States, I've got some concerns about whether that's what the legislature meant by corroboration.
Well, then the legislature can fix it.
Yeah, well,
if
maybe
they
we
want
should
to.
ask them to.
I mean, that's who's supposed to fix this.
Well, because the legislature didn't draft their statute knowing that what we were going to write in white on that particular point.
But the legislature drafted the statute to balance competing interests, which is a perfectly appropriate legislative action. The competing interest of wanting to enable the prosecution at any time, but make sure that we're going to be confident in the result. And we know that for these old cases with child victims when there is corroboration required. And it is a high bar. That was what this court found in White, and it's a high bar because we care about reliability.
But the statute says for more than 27 years after, it has to be supported by independent evidence that corroborates the victim's allegations. It doesn't say independent evidence that goes directly to an element of the crime. They didn't, that's White. And it seems to me that the corroboration has to be something that would be independently admissible. You can't take something that's inadmissible and now make it admissible because of the statute, so there'll be corroboration. You can't do that. But if the evidence is independently admissible in this case, and it corroborates, then there's nothing in the statute that suggests that that's not available to corroborate. That's White that suggests it is.
Well, we do have stare decisis, and this is the decision of this court, and it was arrived at through looked from the outside like a critical analysis of the various factors at play, and fundamentally, it's the legislature's prerogative to craft the legislation as they see fit. They've not revised the legislation since White to change it, and fundamentally, it's not this court's job to improve upon legislation as you see fit. That is fundamentally in our
The statute doesn't say anything about elements. I'm not trying to improve on it. I'm trying to interpret it. You know, you want us to interpret, and I completely understand your argument that, you know, why do we need a tolling to a crime that doesn't have a statute of limitations? Why would you do that?
Right.
I understand that argument. Yeah. It's a statutory interpretation argument. I get it. But I don't see where anything in this statute says anything about that the corroboration has to go to an element of the crime.
Well, the reason it makes sense is because you want the evidence to relate to the crime charge.
Oh, you want to make sure that there's some evidence all these years later when there's a kid that it's not repressed memory, that inaccurately, that's the reason. In other words, the absurd argument makes no sense. I don't see it as an absurd argument. I see that you want to have corroboration in this situation. It's completely understandable why the 16-year-old or adult, you don't need it. But the reason for this corroboration is to make sure that there's some admissible evidence. Don't import something inadmissible. Right. Admissible evidence that corroborates. Nothing that says it has to go to an element of the crime in the statute.
Right, and so what would be admissible evidence that would corroborate? We know from this court's case law and from White and from the statute itself that it can't just be a mental health provider, and it could be a video recording of the event. It could be DNA. There was the legislature considered just having that kind of corroboration. Just give us some DNA and you'll be good to go. They didn't go.
But the whole problem with these cases is they weren't brought forward. And it's very difficult to find any kind of corroboration. But when you actually have something, then to ignore it is different. I mean, the idea that we're going to have, DNA on these things, maybe if they went to the doctor. But then, is it going to be saved? I mean, with these... I don't know.
Well, that raises some reliability concerns too, but I think there is some good case law, and I'm sorry I'm blanking on which case it is, but there is case law from you folks that, you can't just say the guy robbed this bank, and so he robbed that bank too. That's not gonna...
But we have those are great cases. So we've got the guy wearing the mask, and he's robbing the banks, and he has a standard way of doing it. Don't we let that testimony in, that he robbed 3 other banks wearing the mask, with writing the note, this way? We let that in, don't we?
But does it corroborate that this event happened? That this alleged...
Yeah, I think so.
I would disagree, and I think that...
I get it. Look, I'm not saying you're making this up. Well, yeah, you're right in line with what we're talking about. I get it.
One question before we leave. Let's assume for the sake of argument that you are correct that they cannot bring the charges that are indicted. Judge Connors mentioned the possibility that they could proceed with a forcible rape, simply omitting the fact that the child was under the age of 16. Do you agree that and then invoke the tolling provision, which would apply to a Section 20 charge? Do you agree that is something which would be available to the Commonwealth even if you were to prevail here?
There might be other charges. I don't think that charge. I don't think where you say we treat child rape this way and require corroboration because of our concerns about reliability. You can't just say, okay, then we'll act like it's not a child rape, and then we get rid of our concerns about reliability. So I think the answer to that question is no.
But the problem is, of course, it only mentions statutes. It doesn't, if they were to charge it under Section 20 and not allege that the person was under 15, it would not fall within the statutory prohibition. So you're saying we should... I understand what you're arguing, but she's saying we should improve the statute, and you're sort of saying, well, we should also now improve the statute by adding the layer that no rape case of a child under 16 may be brought, even if it's brought under Section 20 as opposed to Section 23 or 22A.
I think there is a reason to be concerned about maneuvering around express statutory requirements to act like they don't exist. So, if the dismissal is affirmed, as I clearly submit it should be because there is no corroborative evidence. They could try, and we may be back here again, but I think there's a tension to an uncomfortable, it would be an uncomfortable outcome to say you can just get around this thing that is designed to ensure that we have reliable evidence by charging the same crime differently and acting like the person who by law is treated as a child is an adult.
Okay, thank you.
Thank you.